I think we are starting, and there's an echo on the laptop in front of me, which is now stopped. Welcome to this member-hosted event. It's part, of course, of the London International Disputes Week 2022. It's hosted by three firms of solicitors, Keidan Harrison, Pinsent Masons, and of course Fox Williams, who's kindly provided the venue and, much more importantly, the dance music. It's also hosted by two sets of chambers. I shall emphasise the first one Essex Court, because that's my chambers, but I have to add very grudgingly, it's also hosted by Blackstone Chambers, and then by Alico, the leading business intelligence firm. Before I start, we should probably move on to the second page, where which indicates the sponsors whom I need to thank. We'll go on for hours if I try and list them all, but a specific mention should be given of the platinum sponsors, Alex Partners and Ancura. Their support makes this entire week possible, and I have to say every year that goes by I get more and more impressed with this particular week in the year. Today, this afternoon, we're talking about fraud, specifically the wide range of interim remedies that are available here in London, tailored to the needs of each case, which help make London one of the major centres for tackling international fraud, and for supporting claims made in other jurisdictions, where often the relief isn't, if I may say so, nearly as good and effective as it is here. On our panel today, we have individuals with substantial experience of commercial litigation and arbitration, and particular expertise in fraud arena. To my right is Evie Meleagros. I hope I've pronounced the name right. She's a partner at Fox Williams and a really good dancer. At the other end, we've got Jennifer Craven, the legal director at Pinsent Masons. We've got Luke Tucker Harrison, one of the founding partners of Keidan Harrison. We have Victoria Windle, who's a silk at Blackstone Chambers, and notwithstanding that, is really nice. And we have Jessica Thorpe, who's a senior associate at Alico. And you have me, your resident comedian, Tony de Garr Robinson, who's a rather elderly silk at 1 Essex Court. Between us, we have a terrifying amount of experience in this area. Or at least between them, I'm terrified. We have quite a lot of ground to cover. I'm proposing to invite questions at the end, but if pressing questions do arise as we go along, please do not hesitate to put your hand up. I reserve the right to ignore you, but if there is something that needs to be said, please say it, and that goes for the panel as well. Let's start with the most well-known and well-established part of the armoury in cases of fighting fraud, the freezing injunction. The court freezes assets pending resolution of personal as well as proprietary claims, and pending enforcement of judgments, whether here or abroad. Now, Evie, could I ask you to kick off, set the scene by telling us about the freezing order remedy?
Absolutely, thank you, Anthony. So freezing orders are considered to be one of the most draconian measures that the English court can order. As Anthony's already explained, we obviously love them. For litigators, they're exciting, they're fast-paced, they're challenging. It's a powerful tool which needs to be obtained with expediency, but also great care needs to be taken with the evidence that you're preparing. You'll have the likes of Victoria or Anthony grilling you on precise details of the evidence. So you need to make sure you get all of that right before you prepare your application. Apologies to those in the audience who know this stuff backwards, but for those that don't, some of the basics for a freezer. It's an interim relief measure. It's an injunction to restrain the respondent, whether they're here or abroad, from disposing or otherwise dealing with their assets. There is criteria that needs to be satisfied. That's been covered over a wealth of case law that we don't have time to go through now, but essentially you need a real risk of dissipation and the claimant has to have a good arguable case. That doesn't mean you need to demonstrate there's a cause of action, because of course you can get a freezing injunction post-judgment when you need to enforce a judgment, but you need to show that you've got reasonable prospects of obtaining judgment in your claim to justify the need for a freezer. There also needs to be no undue delay. The freezers are generally without notice for obvious reasons, because there's not much good if you tip off your opponent by telling them that you're going to freeze their assets. And And with that comes various obligations for the claimant. You need to provide full and frank disclosure. You need a cross undertaking in damages. So these reasons are essentially so you can ensure as best as possible that all the information, good, bad and ugly, is before the court, because the respondent isn't there to tell their own story, and to provide protection for the respondent in the event that the injunction shouldn't have been granted. It's important to remember that the freezer follows the respondent, it doesn't follow the assets. So, and the respondent can be the defendant to the substantive claim, or it can be a third party who is believed to be in possession or control of assets belonging to the defendant. So ultimately, the purpose of a freezer is preservation. It's to ensure that there are assets to enforce a judgment against in the event that the claimant is successful in the underlying claim. How the freezing order is usually set out, it gives a varying level of detail, but it usually captures assets up to a stated figure, and that figure is usually calculated on the estimated value of the claim. The freezing order itself will generally allow for living and illegal expenses, and that figure is usually something that the claimant plonks into the order, but you can increase that figure by way of agreement. And in the past, where we've acted for defendants on worldwide freezers, we've been able to increase allowances for expenses. You usually have to produce an affidavit setting out your client's monthly expenditure to demonstrate why you need a bit more money. You do need to be a little bit careful, though, when you've got a worldwide freezer and you're serving that in other jurisdictions, and if you're getting piggyback orders to enforce your freezer in those jurisdictions, not all jurisdictions recognise the carve-out for living expenses and legal expenses, and sometimes they'll just block you entirely from accessing your funds. And we had that recently on a case where the claimants had got the worldwide freezer against our client enforced in Switzerland. Our client had banks in Switzerland, and those banks wouldn't let him access any money, even for living expenses or legal expenses, and then followed very protracted exchanges with a Swiss bank to try and let him pay school fees and things like that. So that's what a freezer looks like. In terms of the wonderful English jurisdiction and how it can help you if you have a fraud claim in another jurisdiction, we have what's called the Civil Jurisdiction and Judgments Act from 1982, and in that is Section 25. And Section 25 gives the English court power to grant interim relief in support of foreign proceedings. And it's a wide power. It includes any interim relief, which also includes freezers. And essentially, it gives the English court jurisdiction where it wouldn't otherwise have jurisdiction. And usually, it's invoked where the claimant is trying to obtain a worldwide freezer. The proceedings are aboard, and it often generally believes that the defendant has some assets in England and that assets elsewhere, but it doesn't have to have assets here. There was a case now many years ago where the only link to this jurisdiction was an English solicitor. That was a case in 1990. And thanks to Section 25, we also have a corresponding procedural rule under the WIPE in the civil procedure rules, which allows us, in principle, permission to serve orders under Section 25 out of the jurisdiction. It's worth noting here that in other common law jurisdictions that have the power to grant injunctions, they don't necessarily have, or they don't have a statutory equivalent to Section 25. And there was a decision last year which was discussed in more detail earlier this week by a BVI lawyer on the offshore talk called Broad Idea International versus Convoy Collateral. And that was a Privy Council decision. It's a fairly conservative decision. It essentially upholds already established BVI law and procedure, which states that the Eastern Caribbean court rules do not allow for service out of the BVI jurisdiction of a claim where the freezing injunction is the only relief sought. And what the Privy Council said was there was no reason to rock that boat and to leave it as it is. So that case is precedent, and it applies and would have effect in other common law jurisdictions where they don't have a Section 25 equivalent. The Privy Council also said that if the court does have jurisdiction to grant freezers against a party within its personal jurisdiction, you can still do it if you're in with the BVI, but if you're seeking a freezer only outside of the BVI, then it still won't let you do that. And the Privy Council also said that the respondent to a freezer doesn't have to be the defendant, it can be a third party that has hold of his assets, so at least allows that. So not really a problem if you're going to be seeking your worldwide freezer here, but it's worth bearing in mind if you are in another jurisdiction that don't have the benefit of Section 25, which is a very helpful statute for us.
Thank you very much. That was a good scene set. I have to say, I do think Section 25 is a very cool jurisdiction. It gives the courts enormously wide reach, and as Evie says, it allows the court to exercise long-arm jurisdiction as just for a freezing injunction case. It often surprises me it's not used as very much. You'd expect it to be used far more than it is. Anyway, let's now move on to something that is more timely, I suppose, which is how the court is responding to the particular problems created by that most modern form of wealth, namely crypto assets. As everybody here will know, they're specifically designed to put assets beyond the reach of the state. And so the courts have been forced to respond. Luke, perhaps you could tell us how they are responding, in particular with the growing use of person unknown orders.
Yes, thank you, Anthony. Well, persons unknown proceedings are essentially placeholders for unknown defendants. So if there are any Americans in the audience or listening, I suppose it's a little bit akin to the John Doe defendant type cases. They historically arose in the context of squatters, and I remember as a very junior solicitor regularly having to evict squatters from the same chapel in Wandsworth who had raves every time in between the order and the warrant of possession. And of course the issue in those cases was one didn't know who the squatters were, hence the person's unknown placeholder. But more recently they've been brought into use in the fight against wrongdoing and fraud, and this can be traced back to Bloomsbury Publishing Group and News Group newspapers. This was a case involving somebody who had obtained copies of the unreleased fifth Harry Potter book and was offering them for sale, and nobody knew exactly who they were, but that was injuncted, and the individual behind it were injuncted along with the newspaper. And the key thing about persons unknown orders is that one needs to be very careful to define the class, and this is linked, Anthony, to the question of service, because you are identifying somebody in the order who you will then need to serve. So you need to be able to say with as much detail as possible as to who they are, so the court can then go on and make decisions as to service, and often that'll be via an email address or some other medium that they have used to contact you.
So how is it that this has developed as, I think it's fair to say, it's becoming a staple tool in the fight against fraud? How has that happened?
Yes, well that takes us to a case that in fact was talked about quite a lot at LIDW22, which is a case called CMOC versus Persons Unknown. Now, there are a number of decisions, but the main judgment in that case, which is up on the slide, is the judgment of His Honour Judge Waxman. And essentially, in that case, there was a hacking incident, and freezing orders were made against persons unknown, and we'll talk a little bit later about it in some more detail, but also against various non-cause of action defendants. Essentially, the earlier authorities were considered at an ex parte level, and the orders were granted. But then at trial, His Honour Judge Waxman said at paragraph 187 of the judgment, on 23rd of October, I concluded that there was at least a good arguable case that the court had jurisdiction to grant a WFO against persons unknown. But it seems to me I can now go further and say that this jurisdiction is clearly established by reference to the principles underlying the cases, and recognised in cases such as PML and Clarkson, that interim relief against persons unknown will be particularly apposite, where the reason they are unknown is because of their activities as hackers, just as the perpetrators in this particular case were hackers. And I think, as I mentioned earlier, in the context of cases involving hackers, and we are seeing the hackers now move into the crypto world and steal from wallets and that sort of thing, you invariably only know that they are operating at the other end of an email address or some other tool that they've used to communicate to you, and that is important because that is the hook for service of them. And PML and Clarkson, again, cases on the slide, were hacker and ransomware type cases. But I think one of the really important things we learned from the persons unknown cases is the importance of getting that definition of who they are right, and actually bringing to the court's attention how you've constructed that definition, because this falls within the full and frank disclosure obligations. And in another crypto case called Fetch AI and Persons Unknown, the lawyers quite rightly brought to the court's attention that the definition was quite widely drafted, and had they not done that as part of the duty of full and frank disclosure, they could have had problems. And His Honour Judge Pelling, QC, sitting as a judge of the High Court, considered that it was far too wide. Essentially, it extended to those who were innocent in the sense of not knowing or having reason to believe, or reasonable grounds to believe, that assets belonging to the claimant had been credited to their accounts, to their wallets. And so, it's an important consideration when going for a persons unknown freezing order as to how you define it and letting the judge know about that. I was involved myself recently in a case called MSP Capital versus Persons Unknown, and in that case it was quite easy to define the fraudsters, because they were people who purported to own a property against which MSP Capital had made a secured loan, but they were not the true owners. And there's another interesting point that comes from that decision, which is that we were actually able to persuade the court to dispense with the much-loved disclosure pilot in that case. And in fact, we'd had a CMC listed shortly after the return date, and a lot of cost was saved. We also persuaded the court that cost budgeting was not necessary, and in his judgment, His Honour Judge Pelling said, where there will be significant costs inflicted on the claimants who are the victims of fraud and who have a limited number of potential defendants available to them, he went on to essentially say it makes sense in dispensing with cost budgeting because there's an incentive on minimising costs of bringing the action, because you may not know whether you can actually recover them from the persons unknown.
God, I must admit, I gave a little cheer when you make both of those points. There's a great way of getting out of the pilot scheme. Hands up those who think the pilot scheme is a great thing. No, I'm only joking. And also not having to cost budget.
I've got so along with cost budgets.
Yeah, oh God. Anyway.
Can I just also ask Luke a question? So in your case that you cited, what was the court's approach to the cross-undertaking and damages in relation to unknown persons' jurisdiction?
Well, the cross-undertaking damages was given, although given the blatant nature of the fraud, I think there was little concern that it would ever be called upon, and indeed it wasn't.
Yeah.
So there's one particular order that interests me particularly, the rather interestingly named Spartacus Order. Could you tell us about that, please, Luke?
Yes, this is another sort of interesting ancillary order that you can obtain in persons unknown cases, which is an order requiring the persons unknown to identify themselves. And you might think, well, they perpetrated a fraud, why are they going to tell you who they are? But in PML and persons unknown and NPV and QEL, Justice Nicklin said such an order is necessary if, in the event of success of the claim, the remedies to which the claimant would be entitled are to be effective. Of course, a defendant may disobey the court's order and not comply with a self-identification order, as well as the non-disclosure order. But he pointed out that we can't assume that the defendants will breach the order. And in fact, in NPV versus QEL, the defendant did in fact provide a name and address for service. And essentially, Anthony, what the defendants need to do is come out and say, I am Spartacus.
Fantastic. In person unknown cases, it'll often be difficult to know where the defendant is. Evie, I wonder if you can talk about how to establish jurisdiction in those cases and how to effect service?
Yes, I mean, so where your defendant is unknown, your defendant's jurisdiction is generally going to be unknown, even if the claimant can identify certain categories of persons, as Luke was just explaining, and can probably say they are likely to be outside of England. This precise location is generally going to be unknown. So when you are preparing applications against persons unknown, you need to think about all the other tag-ons that you need, and you need a shopping list essentially. And so the key things the claimant needs to think about is consider whether permission to serve out the jurisdiction is required. The answer is probably yes, and consider whether an order for alternative service is also required. And as I'm sure, again, many of you in here know, when you need permission from the English court, you need to show three key things. The first one is that the claim falls within one of what are known as the jurisdictional gateways under the CPR, which is various categories of scenarios that you can say your case falls within to justify it being England. 2, your claim has a reasonable prospect of success. And 3, that England is the proper place, which is a slight catch-all criteria. On part 2, on criteria 2, which was reasonable prospects of success, usually in persons unknown cases, you also need to think about governing law, because there's unlikely to be a nice agreement with a governing law and jurisdiction clause that says, all these people I don't know, these are the law and jurisdiction that applies. So you need to apply the usual laws, Rome and so on, to work out what governing law should apply. In crypto cases, the case of Iron Sciences, which is up there, the judge considered this, and that judge concluded that the lex situs of the crypto asset was the place where the owner was domiciled, or at least there was a serious issue to be tried that was the right answer. Last week there was a decision in the Tulip trading case, which I'm sure many of you saw, where a jurisdiction challenge was upheld. It wasn't a persons unknown case, but the commentary from the judge in that was that position has to be the right one as well. That where the asset is where the owner of the asset is domiciled is the lex situs. And on the third limb, where the defendant is unknown, it's a bit difficult to identify any other suitable forum. And what the courts have done is, if all the other factors point to England, the claimant's domicile, where the assets are located, damage occurred, witnesses, etc., then that's good enough to satisfy limb 3. In Tulip trading, the judge said the same thing. Interestingly, in the Tulip trading case, the claimant obtained service to Tulip's not up there because the judgment only came out last week, the week before, but the claimant had obtained permission to serve out the jurisdiction on the defendants. The defendants weren't known, but the judge overturned that last week on the basis that there was no serious issue to be tried. But the other commentary around that was that everything else she was satisfied did point to England. When you are applying for service out of the jurisdiction in a person unknown case, or indeed any case that has a freezer or anything that needs to be brought to the respondent's attention with some level of expediency, you need to think about whether you want alternative service when you're going out of the jurisdiction. A freezing order isn't going to be much use if it's not served on the respondent for another 3 months because it's going through the Hague Convention, or because of Brexit via various 27 different local laws on service. And it can, as I'm sure many of you know, take quite a while, especially if you're going through the local courts. So alternative service orders will only be made in very exceptional circumstances because you're asking the court to circumvent the Hague. But where there is good reason, the court will grant it, and good reason, urgency is a good reason, and freezing orders are usually urgent. An alternative service order was granted in the Fetch AI Limited case, which also is a crypto case, and that the claimant got an alternative service in respect of a world freezer, a disclosure order, and a banker's trust order. and there have been a few other similar cases where crypto has been stolen from wallets, and the action is against person unknown, where alternative service has been granted out of the jurisdiction. And there is certainly what we're seeing at the moment is the courts are being more inclined to find ways to grant these sorts of orders where there's a prima facie case of fraud in a global effort to tackle fraud, and that's happens at the moment to be increasingly coming up in the context of crypto. But as we just saw in the tulip trading, that's not always the case.
Thank you very much. Now, a final practical point in relation to freezing injunctions. In my experience, it's often critical for the claimant to have an investigator as an active member of the litigation team, and this is where Jessica comes in. Jessica, how can an investigator help with the preparation for a worldwide freezing order?
Well, in several ways is the obvious answer. I think in an asset tracing exercise of this kind, investigators can identify and map assets and the structure within which they are held via two main manners. The first is information, and the second is intelligence. With regard to information, we use a wide range of publicly available tools, and this would include corporate databases, land registries, maritime databases, vessel transcripts, plane spotting databases, social media, etc. And this is obtained both online and or in person, depending on the jurisdiction. With regard to intelligence, thankfully, because fraudsters tend to use the same jurisdictions and operate in similar sectors, we have a wide established network of sources around the globe who are able to relay often information with regard to certain entities or subjects. In addition to that, on a matter by matter basis, we would also create new sources, and these may be former employees or former persons with knowledge of the subject in question, all of which can help build a nice jigsaw puzzle of the maps, of the assets necessary for the freezer injunction.
What about when you've actually got the freezing order in place? How can an investigator help at that stage?
Yeah, I don't think it's always an obvious choice to retain an investigator at this stage, but I do think that it does have its uses, and we can help to keep an eye on certain assets. To give you an example of this, on a previous matter we worked on, we had obtained a world freezing order against a subject who had a large property portfolio around the world. Like all great fraudsters, he of course said that he was short of money, he was in desperate need of funds, he was close to bankruptcy, which immediately set off alarm bells for us. So we consequently did two things. The first was we reached out to sources we have in the real estate sectors in the relevant jurisdictions where the defendant held property to try and understand if he was attempting to sell his property on the side. And the second thing we did is conduct frequent searches of all the real estate companies in the respective countries to see if he was listing them, either via a small company or a large one. Lo and behold, what we found was that in one jurisdiction, the defendant was indeed selling one of his most valuable houses with a rather small agency and a certainly below market price. And in another jurisdiction, we found an interior designer who was posting on social media the nice changes she was making to another property owned by the subject in a rather sunny destination, which of course we all provided to the legal team and thankfully prevented the assets being sold.
Thank you. I don't know why, but a story has just popped into my head. About 15 years ago, one of the really big fraud cases, I don't think I'm allowed to name the name, but it would have been one of the cases that was in the papers quite a lot. And the main defendant eventually, when he saw that the game was up, skipped the jurisdiction. And for about 2 or 3 months, nobody could find this man. And it was the reason why I'm telling you this story is because my son was at a prep school with his son, and I didn't even know that at the time. But about a few days later, a few days after he disappeared, I remember discussing it with my wife, and my son popped up and said, "Oh, he's in Paris." So anyway, it just goes to show that intelligence really does work. Now, anyway, of course, freezing orders are only part of the armoury. You're closing the stable door, hopefully, before the horse has bolted. But another vital element is asset disclosure orders, which are designed to help find the horse in the first place. There are, of course, many different types. I'm sure you're all aware of them. One type, perhaps the paradigm type, is a straightforward disclosure order, which is made directly in support of a freezing order. Victoria, perhaps you could tell us about the court's approach here.
Sure. I'm going to move that away. Feels intrusive. Okay. So I'm sure you all know asset disclosure orders are an ordinary ancillary order to a freezing order, because the court has recognised that it's no good freezing the assets if you don't also identify them and have some mechanism for making sure that you can police the order. And the court does not like to make orders that can't be policed, or that it can't check will actually be enforced. So it's got a couple of jurisdictions that it can do that under. There's a power under the CPR 25(1)(1)(g), or under section 37(1) of the Senior Courts Act, which allows the court a really broad discretion in terms of the injunctions that it makes. And I'll read it out because we might get to the end to some of the other kinds of ancillary relief that are sometimes ordered by the court. And they are ordered pretty much always under this provision, which is the High Court may order, whether interlocutory or final, may by order, whether interlocutory or final, grant an injunction or appoint a receiver in all cases in which it appears to the court to be just and convenient to do so. And of course, injunction there is a very broad word, just you must do this. So that gives the court a lot of power. So the requirement to disclose assets is one that the court has recognised for years now. As an adjunct to the freezing order, it's completely standard. The courts expect you to be looking for asset disclosure to support your freezing order. And they've made clear in recent years just how far that obligation goes. So firstly, it is not to be circumvented. The requirement to disclose assets can't be avoided by, for example, saying, well, I will, of course I will, if I lose my discharge application. So a defendant who's issued a discharge application on jurisdiction grounds or whatever, can't use that as a basis for saying, I shouldn't have to provide disclosure until that discharge application has been determined. Because the courts recognise that it takes a long time sometimes to determine a discharge application. And then, of course, it's appealed. And in the meantime, the freezing order is a dead letter. And it was made probably without notice for a reason. It needs to be effective immediately. So that doesn't work. And that's been understood and agreed at least since the Court of Appeal in VTB Capital and Meleagros in 2011. It was more recently argued in the Kazakhstan Kagazi case that asset disclosure should await the outcome of an application which might result in a payment into court. So, of course, you know that you can have a freezing order discharged if the defendant pays into court the amount that would otherwise be frozen under the order, because the payment into court acts as not security for the claim, obviously, because that's not what a freezing order is, but it means that there is a pool of assets which can't be dissipated, and the fact that the defendant is willing to pay it into court is enough to make that happen. Now, how often that happens, I'm not sure. In my career, I've never seen a defendant pay the money into court, so perhaps that feels like a theoretical solution. But
she clearly does big claims.
Of course I do. But if so in the Kagazi case, one of the defendants was saying, well, I've got this application to pay some money into court and that should be enough, and then it could be discharged, and so I shouldn't have to disclose. And the court said, no, that's not going to work. We need to know right away what's going on. And if you make your application, if it's successful, and if it isn't challenged that it doesn't actually amount to a payment in and so on, then you can make a discharge application. But in the meantime, do your disclosure. So it was argued in Tatneft and Bogolyubov, probably, I hope, that the defendant should only have to disclose assets up to the value of the sum frozen. So as Evie mentioned, your freezing order mentions all of the defendant's assets within the jurisdiction up to the sum of, or alternatively worldwide, up to the sum of, and mentions a sum. And that sum is the amount that's frozen. And if they can show that assets up to that amount are frozen, then they should be able to do what they want with the rest of their assets. And that would seem to be a fairly reasonable reading of the order. But in Tatneft, it was suggested that if the defendant disclosed assets up to that amount, because that's the amount that's frozen and they've disclosed assets up to the amount that's frozen, they shouldn't have to disclose any more. And the court said, no, we're not having you cherry picking which assets you disclose and disclosing the most unenforceable assets. And also, although, again, a freezing order is not security for the claim, it is merely to prevent unlawful dissipation, we recognise that things change between the date on which you get your freezing order and your final enforcement. And by then, probably quite a lot of creditors will have come out of the woodwork. And so it's not enough for you simply to disclose assets up to the amount of the freezing order, provide the whole lot of disclosure, disclose everything. So the court did recognise that there could be circumstances in Tatneft, that there could be circumstances in which it might exercise its discretion to vary the freezing order to require disclosure only up to a certain amount, or to require no further disclosure if sufficient disclosure had been provided. But that would be an application to vary the freezing order, so it would be for the defendant to show why it's right in the circumstances that they shouldn't have to disclose more assets. And in order to do so, they would probably need to show that the request to disclose assets was perhaps an unlawful attempt to cause that disclosure of more assets would prejudice them in some way, or that it was an attempt perhaps to put collateral pressure on them that was improper, so an improper use of the court's powers. So it's for the defendant to come up with some good reason why disclosure shouldn't happen. And of course, defendants often say, I can't disclose my assets. Those claimants, they're no better than they ought to be, and I don't trust them. And as soon as I've disclosed my assets, I will suffer as a consequence. And the court's response to that has been to recognise that when it's using one of its nuclear weapons, those really intrusive orders, it is right to protect the defendant. It's only holding the ring. This isn't punitive. So in those circumstances, the court has been increasingly willing to look at confidentiality rings and to consider to whom disclosure should be made. And so disclosure might be made only to a very limited number of people, a very limited named number of people. And indeed in Tatneft, even the claimant was excluded from the confidentiality ring because the claimant didn't need to know about the defendant's assets. The claimant just needed to know that the assets had been disclosed and were therefore there was a possibility of enforcing the freezing order. It isn't necessary for them to see those assets and to potentially use that information for other purposes, which of course the court absolutely does not allow. The court's absolutely clear that when disclosure has been made under compulsion, the collateral use obligation applies, and the claimant who has obtained that disclosure under compulsion cannot use it for a collateral purpose. And a collateral purpose we know from Lacatamia, which was a search order, but in that case, information which had been obtained on a search order was reviewed by the claimant for the purpose of proceedings which were in existence before the search order had been obtained, but were not the proceedings in which the search order had been obtained. And the court said that is absolutely a breach, that is not allowed, and ordered indemnity costs against the claimant, although it actually also retrospectively allowed them to review the material because there was no prejudice to the defendant and the defendant was clearly a wrong un. But the point stands, it was clearly a breach of the collateral use obligation, and the court wanted to signal its severe disapprobation of that sort of behaviour by the indemnity costs order against the claimant. So the solution to any suggestion that there could be collateral use actually protects the claimant as well, by keeping it within a tight identified confidentiality ring, and is the approach that the court uses to balancing the interests of the claimant and the defendant. So that's anti-avoidance. You can't, basically. What about how comprehensive does that disclosure have to be? Now, the cases up here about this, I'm sure, are familiar to you all. You know that the defendant can be required to give details of assets in which he has no present legal or beneficial interest, but over which he exercises control. And Pugachev is the paradigm example of that. Pugachev was a discretionary beneficiary of a trust. So he had no right, he had no legal right, he had no crystallized beneficial right. He just might have a right in the future if the trustees so decided. But in Pugachev, the court ordered that because there was some credible evidence that suggested that he exercised control over the assets in the trust, those had to be disclosed. Now, these are assets which had to be disclosed because they might be his assets, and they effectively, and therefore they might be assets against which enforcement would ultimately potentially be sought. So effectively they fall within the assets which are his, which he has to disclose, and the purpose of the disclosure of the assets was to make sure that whilst whether or not they're in or out of that category of assets, they are secured in the meantime. And the court considered what the test was for showing whether for obtaining an order in respect of assets in which the defendant doesn't have a legal or beneficial interest. And the court said you don't need to show that the test for a freezing order is met in relation to those assets. You just need to show that there is credible material for thinking that the asset may later become the subject of a freezing order. So quite willing to support the investigative process there and to hold the ring in the meantime. So that's Pugachev. And in Izbilan and Turk, there was an application of the same principle. The defendant was ordered to disclose specific documents or categories of documents, bank statements in that case, for the purpose of enforcing the freezing order, in order to identify what had happened to sums of money which appeared to have been dissipated. You know, if they've been dissipated, where have they gone and who do they belong to, and that. And so that was an application of the same principle. I know others are going to address orders obliging the defendants to disclose the source of funding for their legal expenses, but again, that's the same principle. If somebody else is paying your legal expenses, are they using their own money to do it? Very kind, but perhaps a little unlikely. Or is it actually the defendant's money? And so that's where these orders about disclosure of legal expenses fit into the same principle. And the court is also willing to order disclosure from third parties who may hold assets or asset information on behalf of the defendant. And there are different potential routes for that, each with its own test. You'll need a barrister to tell you, obviously. And I know you'll hear about some of those from some of the others, but they include freezing orders against third parties. You heard mention of non-cause of action defendants from Luke. So those are third parties against, they're not accused of any wrongdoing, but often the wife, sorry to say, holding assets which aren't really hers and which can be accessed for enforcement purposes. So that would be a non-cause of action, a third-party defendant against whom a freezing order is made directly. Bankers' trusts order, so in relation to proprietary assets, seeking information from a bank to support a proprietary tracing claim or tracing claim. Norwich pharmacal orders, which I know Jenny's going to talk to you about, and potentially third-party disclosure orders, although third-party disclosure orders, they may be covered by one of the other ones. They're difficult, but potentially third-party disclosure orders. Note the points that have been made by Evie about jurisdiction. For each of these different potential orders, each of this relief, you're going to have to think about jurisdiction in order to help identify whether the target who has the information is a person over whom the court will exercise jurisdiction, or whether you need to go at it through the defendant because the court only has jurisdiction over the defendant. So jurisdiction, always an interesting one, yet more interesting after Brexit. Wait till we get to enforcement after Brexit. It's all very exciting. But that's something else to think about.
And I think just thinking about how things work in practice, I think those cases that you've referred to are quite interesting, because I don't know in your experience, but certainly in mine, it's very difficult to get disclosure out of a fraudster, and it's a very iterative process about pulling all the information out and using the law to help you to get to that.
And as you say, iterative, you get one piece of information and then you squeeze it as hard as you can to find leads and other potential sources of information. And ideally, banks who essentially just sit back and say, well, if you order us, we will, and you can do it. But each piece of information you get, you squeeze and you follow it a bit further. And for that, you might use specialist investigators or just your own experience as investigators for fraud. It's absolutely true. Very difficult to get information from fraudsters.
Now, when it comes to disclosure of a defendant's assets, as Victoria's already mentioned, one of the awkward areas is where a defendant seeks to pay his costs or her costs or its costs out of a particular fund, and there's generally an obligation on the defendant to notify the client of the fund. There have been some interesting cases in this area in recent times. Luke, I wonder whether you could tell us about those.
Yes, thank you, Anthony. Well, we heard earlier the freezing order being described as a nuclear weapon of civil and commercial litigation, and it is just that, and it can in fact impact on the ability of the defendant to obtain proper representation. We know proper representation doesn't come cheap in these cases, and of course for those of us in this room, when we receive potential instructions on a new freezing order case on the defendant's side, obviously the most important question for us is how are we going to get paid, and it is a question that we need to look at very carefully. The standard form freezing order, we're of course all very familiar with, requires you to notify your opponent of the intention to spend money on legal costs, where they're to come from, and how much they will be. But crucially, that does not extend in the standard order to money coming from third parties, family, friends, business associates, etc. But the decision to be wary of, and which can lead you to becoming a cropper, is the case of BTA Bank and Abliazov number 10, as it is known, because Mr. Abliazov has been a very naughty boy. And in that regard, Kleptopia, I can definitely recommend to those of you who haven't read it. Will teach you a lot about Mr. Abliazov's shenanigans. But the number 10 decision essentially examines the situation where one has what's become known as the extended definition of assets in the standard freezing order. And that's extension of the definition of assets to extend to assets which directly or are indirectly owned or can be dealt with as if they were owned by the defendant. And in the case of Mr. Abliazov, he had the ability to seemingly use a £10 million loan facility in whatever way he wanted, which certainly didn't appear particularly commercial. Now, obviously, at one end of the spectrum, we have people like Mr. Abliazov, and at the other end of the spectrum, we have other defendants who are perhaps a little bit more normal. And I myself was instructed by a defendant who seemed to be much more normal than Mr. Abliazov and Mr. Wojciechowski in some litigation that has been come to be known as the Ton State litigation. There are two reported judgments in this case where we had more than a walk on park because we became a party to the litigation. A little bit of background to this: Mr. Wojciechowski became bankrupt after a dispute involving a company called Ton State that historically owned about £1 billion worth of real estate that were used as Hilton hotels. And following his bankruptcy, I was instructed to make sure that he complied with his duties to his trustee and other matters. Mr. Wojciechowski was bankrupt and was not funding his own legal costs for reasons that will be pretty obvious. And as was recorded in the judgment, his legal costs were provided by a business associate and by his brother, who was an Israeli lawyer. So one would think there wouldn't be a problem there. He doesn't have to disclose payment of those legal costs because he's not paying them, and they're being paid by a third party on account of costs. All was well. Mr. Wojciechowski didn't want the third party to be identified. Quite understandably, he was worried they would become targets of the extremely aggressive claimants in the action, and one of them was his brother. And so, owing to confidentiality, they were not disclosed. Shortly after, certain letters were written to the trustee, which found their way back to Tonstate, which maybe implicated Tonstate in potential causes of action by the insolvent estate. My firm was then joined to the proceedings as a party, seeking a declaration that we'd receive funds on account of costs in breach of the terms of the freezing order. The sort of short way of describing the outcome was that after 2 hearings before Mr. Justice Zaccaroli, it was concluded that those funds were perfectly properly received, but most crucially that the funds paid by these 2 third parties on account of legal costs did not come within the Ablyazov definition of assets. They were not the same as a loan facility, £10 million that you can use however you wish. But it is very important, I think, that practitioners do carefully look at the source of the funds they're receiving. In the second round of that particular application, because having won the first round and asked for costs on the indemnity basis, Tonstate sought to fight that proposition. The court looked at the question of whether due diligence on the source of funding was adequate. Bank statements had been taken and they've been analysed, and going back 3 or 4 months. And I think that is certainly something that I think the court will expect parties to do when looking at how they're being paid. Which takes us on to the environment we now find ourselves in, where we may end up being instructed by a party who either may be sanctioned or may be the indirect owner of something which is sanctioned or otherwise come and become touched by the sanctions regime. And I think this then makes the source of funding, particularly in fraud cases perhaps involving nationals from countries that may be subject to sanction, all the more important. The Economic Crime Transparency and Enforcement Act 2022 has recently been introduced with quite a chilling amendment to Section 146 of the Police and Crime Act 2017. And what this says is, in determining for the purposes of subsection 1 whether a person has breached a prohibition or failed to comply with an obligation imposed by or under financial sanctions legislation, any requirement imposed by or under the legislation for the person to have known, suspected or believed is to be ignored, i.e. strict liability if you are receiving funds without having an appropriate licence under the sanction regime. So I think what this does is put us practitioners in these complicated cases in a position where we've got to be very, very careful in looking at how we get paid when acting for parties in fraud litigation, and particularly those subject to freezing orders.
That puts a shiver of fear down my spine. Barristers usually see themselves as beyond all, filthy questions of money. But we're all in it together on this one. Now, Victoria has already touched on disclosure orders against third parties and the different sorts of orders you can get. Jennifer, I wonder whether you could tell us about the jurisdiction to order often innocent third parties, such as professionals and banks, to give disclosure, and what types of third-party disclosure orders are available in the English courts.
Yeah, thank you, Anthony. I think at the outset, and one of the points that I've noted, having listened to my fellow panellists today, is that fraudsters are always innovating. And I think one of the greatest strengths of the English common law is that it's able to be flexible to sort of meet the needs of the victim and deal with the novel situation that they're in. Having said that, I think that the English court, recognising that it sort of has this expansive power to order third-party disclosure, at the same time has taken a rather cautious approach over the recent years in terms of ordering third-party disclosure. But I'll expand on that a little bit further later. Just to come back to your question, there are two really important avenues of obtaining third-party disclosure that come to my mind, and that is, of course, Norwich Pharmacal Relief and also bankers' trust orders. There is, of course, a route pursuant to CPR 3117, which Victoria has already touched on, and I wouldn't have time to get into the detail on that today, but just going back to bankers' trust orders, I think it's fair to say that in England there's a fairly sort of narrow circumstances in which you would be able to obtain a banker's trust order. And I think what that really means is that a victim needs to show a clear-cut case of fraud. Ultimately, I think what the victim needs to show here is that funds have gone through the bank account or the financial institution against which it's applying for information. And ultimately that information is going to identify the location of the assets and assist with its preservation. Slightly more broader relief is the Norwich Pharmacal Relief. And in those circumstances, a victim needs to show that there's a good arguable case that a wrong has been committed, and that there is an innocent party that has become mixed up in the wrongdoing, and also that an action needs to be enabled. This information can enable an action to be pursued against the fraudster. So the respondent actually has to have the information to be able to provide to the applicant. And I think what we tend to see in practice, therefore, is sort of Norwich Pharmacal Relief and Bankers Order relief being applied for at the same time. And in circumstances where the facts are slightly narrower, perhaps the victim won't necessarily get the Bankers Trust Order, but will subsequently be able to secure Norwich Pharmacal Relief.
So how are you seeing the Norwich Pharmacal jurisdiction being used these days?
Well, I mean, I think it would be remiss of me to say that if a victim is applying for Norwich Pharmacal Relief in the English courts, it doesn't come without its challenges. Certainly, I think what we've seen is the courts taking a rather stringent approach, making sure that applicants meet the necessary legal tests. I think if we look at the case of Ramalos Trading Limited, what we tend to see there, when we actually saw a reference to Justice Flo's analysis of, in singularis, of Norwich Pharmacal Relief being very narrow in scope. And I think if we look at Ramalos, a couple of things came out of that. The first being that if you're applying for Norwich Pharmacal Relief, it shouldn't be a case of obtaining discovery to obtain evidence. It's not an expansive test or exercise to obtain discovery and evidence, and it shouldn't be a fishing expedition. An applicant really does need to look at the relevant test before making that type of application. But of course, in Ramelos, one of the points that the court was considering was the statutory regime in place. And I think in Ramelos that they considered the Evidence Proceedings in Other Jurisdictions Act 1975, and in that case the court said, look, because there's a statutory regime in place here, the Norwich Pharmacal jurisdiction can't apply. But having said that, I think there are also some really good examples of the English court being flexible and showing that Norwich pharmacal relief is available to victims. There's quite an interesting passage in the case of Cartier, where Lord Sumption referred to Norwich pharmacal relief being available to provide information, of course, which is what we usually, and many of us in this room would use the Norwich pharmacal jurisdiction to obtain, but also an idea of where in circumstances an intermediary has become mixed up in the wrongdoing, that actually that intermediary should be putting the facilities beyond the reach of the fraudster. And there was quite an interesting example given about a freight forwarding company who was holding on to goods, not only did that freight forwarding company need to provide the information to the applicant, but also they needed to put the goods beyond the reach of the fraudster. So I think that's a good example of the English court using the tool quite flexibly. And I think, of course, as Luke and Evie have mentioned, crypto cases, tend these days to always have a Norwich pharmacal application, sort of appended to them. So they're almost becoming a sort of test use case for crypto cases. Just one word of caution on crypto. There was a recent judgment called Walker and Blockchain, I think in April, just in April 2022, which was a slightly disastrous application in terms of for the applicant. The applicant was actually heavily criticised for not agreeing the sort of reasonable costs of to pay the exchange and not actually giving the exchange enough time to consider the request for information. So I think that shows that an applicant really does need to meet the stringent legal test, and any application before the English court will be scrutinised. But I know that Luke also has some interesting points to make on the crypto case side of things.
Exactly. Luke, could you please tell us about the availability of the Norwich pharmacal jurisdiction to be used to obtain information from parties who are outside the jurisdiction, something of a burning issue these days?
Yes, well, it is a burning issue, and essentially at the moment it can't be used to obtain information from outside of the jurisdiction, or maybe it can't. And I think that's the jury is perhaps out on the question. The authority that says it can't is the AB Bank and Abu Dhabi Commercial Bank decision. There was a recent unreported decision of the aptly named Mr. Dollar Bill Limited and Persons Unknown, and Binance and others. Mr. Justice Trower granted prohibitory injunctions restraining dissipation of Bitcoin invested by the claimant through bittrust.net. The claimant claimed that he'd been victim of a fraud perpetrated by those behind bittrust.net. And in addition, a Norwich pharmacal order and bankers' trust orders were sought to assist in the tracing exercise. There had already been a tracing exercise to establish a good arguable case, and now there are these forensic companies that can follow the Bitcoin on the blockchain and produce a report for your applications in quite a quick way. Rather unhelpfully, despite having looked at the transcript of the judgment, the judge doesn't actually tell us exactly why that order was made.
Against a foreign respondent.
Against essentially a foreign respondent. But I think this is going to be developing in the area of crypto cases, because one of the issues with crypto cases is one doesn't really know where the defendant is, where the exchange is, where the information is, because it's the whole concept of this distributed ledger. So I think we are going to see developments in the ability to serve out of the jurisdiction, obtain information from outside the jurisdiction. I should also mention that at one of the panels earlier on this week, the Cayman case of SR was mentioned, and I understand that an application has been made to the Privy Council in June of last year. It hasn't been listed yet, but that is a case involving service out from Cayman of Norwich Pharmaceutical Orders, and that may shed some light on the situation. There was we can be bang up to date, Anthony, because there was a BVI case I read about this morning, dated the 4th of May, in a case called Chain Swap, a decision of Justice Jack in the BVI. And I was very excited about this because I thought this is going to answer some of the questions. It's another crypto case. And he starts actually saying, by Mr. P is appearing for the applicant, asked whether I would give a written judgment in light of the novel aspects raised on this application. Started reading it with real anticipation. He doesn't actually grant Norwich Pharmaceutical Order service out of the jurisdiction. What he does do is sign some letters of request addressed to the Croatian courts. It's paragraph 13 of the judgment, and he does so on the basis that some of the crypto had gone to a Croatian exchange called Electrocoin, and according to their terms of business, they should hold know your client information. So that was quite interesting, because that would seem to be a bit of a hook, not for Norwich Pharmaceutical Relief, but for these letters of request. And the other interesting thing that actually comes out of that decision is that how they essentially focus on the definition of the class of persons unknown, he didn't like them being defined by reference to people who effectively perpetrated theft of the cryptocurrency. He wanted them to be defined by reference to holders of particular wallets with the hexadecimal code that identifies the wallet. So that it does tell us something, but not quite what I was hoping it was going to tell us.
And I think we were talking before, Luke, about crypto cases generally and how they're sort of only newly developing in this jurisdiction. And I think often it's the case that you'll find that, we read these judgments, they're ex parte, there's not actually a defendant on the other side to challenge what the law is. So it's quite interesting. And I think Evie mentioned the Tulip decision and how jurisdiction was actually challenged. And I think it's going to be quite interesting to watch how this space develops. It's relatively new, and it'd be nice to see defendants coming in and raising the legal challenges and just seeing what the outcome is going to be of that.
But the important point is that there's been a little informal competition between all of us as to who can cite the most recent case, and I'd like to declare that we have a winner to that competition. I do think actually that the existence of the crypto problem and the way in which the courts have tried to wrestle with and deal with that problem is a good advert for the common law system. It's a good advert for the willingness of judges actually to review matters, points, principles that were thought to be long established decades ago, with a view to dealing with a new problem in relation to which the old rules really are inadequate. Actually, on that point, perhaps we should have a little chat about SR. Jennifer, I wonder whether you'd like to tell us about SR and about how the other jurisdictions may have something to tell us about.
Yeah, I fear that Luke may have stolen my thunder slightly, but I know that earlier on in the week, obviously there was a lot of discussion about offshore jurisdiction and how they've approached the Norwich Pharmaceutical jurisdiction, and clearly there's quite a distinct difference after the SR case, particularly in how the Cayman Court of Appeal has approached the jurisdiction, which is much broader than the English court. So, I don't think we need to go into the details of how each offshore jurisdiction handles Norwich Pharmaceutical relief, but just suffice to say, for the purposes of this talk, I think that SR will really encourage the English court to look at Norwich Pharmacal jurisdiction and whether it can be broadened or used better to assist victims of fraud. But I think ultimately what it really comes down to is that each application is fact dependent, and nobody in the English court is going to get away with making an application that doesn't comply to the sort of stringent tests that have already been set out. So it's sort of a watch this space situation, but as long as you're not seeking or pursuing a fishing expedition, then presumably, hopefully, you will get what you're looking for.
Thank you. Now, we've been going for about an hour. We've got a little bit more than an hour. We've got some time left. We've covered the basics. We've covered freezing orders. We've covered disclosure orders against the defendant and against third parties. But of course, there are other orders out there that are available, which I think we should spend some time talking about, starting, of course, with the old-fashioned search and seizure order. Victoria, I wonder whether you could help us understand the range of orders that are available, starting with what used to be called the Anton Pillar.
Sure, of course. A quick canter through some of the orders that are available, some of the different kinds of innovative relief, which I've sort of trailed a little bit by reading you the breadth of section 37.1, which allows the court to make pretty much any order it can be persuaded is a good idea to make. Whether you keep it, or if you ever get a defendant who stands up, is something else. But the court can be persuaded to make an order if you can convince the court that there's a need. But you asked about Anton Pillars. Let's go to those. So the search order is, of course, the other one of the two of the court's nuclear weapons. It's available when the claimant has a very strong case, and it can only be justified where it plainly appears that justice requires the intervention of the court, or otherwise the plaintiffs may be, claimants now, substantially deprived of a remedy. So it's a high test. It's always been a high test for a search order. But it does remain a vital tool for preserving documentary evidence. I think, though, that the development of the modern form of documents has highlighted the distinction between a search order, which is designed to preserve documents in exactly the same way that a freezing order is designed to preserve assets, and a disclosure order, which is designed to give early disclosure of information which ought to be coming in the ordinary way under the disclosure regime, but to give it early and potentially on a without notice basis. And the search order was never intended to do that, but the original search orders, Anton Pillar 1976, pretty much everything was on paper, and a search order was executed by going to the defendant's various premises and searching through documents to see which ones were relevant, and then taking away the relevant ones or copying them. Since then, everything now pretty much is electronic, and the volume of documents has just magnified by enormous amounts. It's orders of magnitude. So the standard form search order, I think I don't know if anyone else would disagree with this, but I think that it is no longer fit for purpose. The standard form search order still refers to going, and it anticipates that electronic documents will be reviewed on screen and then either printed or copied. There's a footnote which acknowledges that it might be envisaged that forensic images will be taken, and notes in those circumstances a computer specialist needs to be obtained. That's it. Nothing about it at all. Now, obviously, we all know search orders these days. You go, you image all of the hard drives, the external accounts, and so on. You suck it all down into your the hard drive that your computer expert has provided, and then you take it away. And the effect of that, of course, is that you don't look through each document to see what there is. You don't have any idea about the universe of documents that you've taken. And the court has the other point about that is that because the court recognises now that so much documentation tends to be electronic, I think the courts are getting perhaps less willing to order a search of hard copy documents, or less willing to order searches of lots of different premises, and particularly, of course, domestic premises. So the courts now, I think, will test an applicant to say, well, if you go to the office and you seize the computers in the office and you image those, and then from them you access the cloud and you image all of that, why do you need to go to his home as well? What more are you going to get? And of course, they do still make them. The court does still make old-fashioned search orders where you turn up with a raiding party at 5 different locations and you seize all of the hard copy documents. But I think it's a little bit more, that the court is, I think, more aware that that's not necessarily a default, and that the court is, as everyone has stressed, keen to be innovative but to protect the defendant. And one way of doing that in relation to search orders is to say, do we really need to order to make an order that requires a search in a domestic premises or at 5 different premises instead of only 1. So one of the examples of that is the case of London Partners Capital and Utcan. The claimant wanted to carry out a search at a number of different locations, and the court said, okay, you can search that location, but there were some which were storage facilities, and the court said, no, I'm not letting you go and carry out a search at the storage facilities, but I will give you an injunction that prevents the defendants attending the storage facilities until you've seen what you've got from the premises I will allow you to search. So it's again a balance and a bespoke order. I'll give you an injunction that stops the defendants accessing the storage facilities until you've seen whether the more narrow search order I've given you is effective. In A and B, the debate was about whether or not the claimants could look at the documents which they had been able to seize. And in A and B, the claimants agreed to only seize electronic documents on the basis that the hard copy documents probably wouldn't add significantly to that. And the court considered whether or not it was appropriate to allow the claimants to review those documents, effectively give them control over that review process, and said the standard order in relation to reviewing documents is it's done by the defendant, and it's done in the ordinary course of events, and you don't get the claimant to do the defendant's disclosure for them and at an early stage. But in appropriate circumstances, the court will make an order of that kind. So in A and B, it was justified because there were safeguards for the defendant. The claimants needed quickly to know if confidence had been breached, and the claimants were better placed than the defendant's solicitors to determine whether the documents contained or derived from the claimant's confidential information. But it does seem to me that if you're going to search, to want to look through the documents that you've seized in a search order, however you've seized them now, but electronic documents, you're going to need to show the court why the documents need to be reviewed now, why it's necessary that the claimant should identify which documents should be disclosed at this stage, and what, rather than the defendants identify which documents should be disclosed at this stage, and what safeguards are in place for the defendant, and why the interference with the defendant's rights is the minimum necessary in the circumstances. So an order of that kind was made in A and B. The order was then that keywords would be applied to the data collected. The defendants would inspect the responsive documents to remove only privileged or confidential documents, and the rest would be delivered to the claimants for them to review. So almost an accelerated disclosure process, but with it effectively being carried out by the claimants, the defendants having been protected by first being able to remove privileged and confidential documents. But that needs to be justified. It's not, as I think people sort of thought because of the way old-fashioned search orders worked, that once you'd got a search order you could look at the documents. That's not the case. You get a search order, it preserves the documents. You want to look at the documents, you've got to make another order. And you have to show why you need to look at them. And you need to show what safeguards you're putting in place. I should just give a quick shout out to Mr. Justice Arnold, who considered this point in TBD and Owen Holland and Simmons, and did a detailed history of search orders before pointing out that distinction. A masterclass in how search orders work and why. So I think also if you're going to be wanting to look at documents before the return date, when you're searching, when you're asking for a search order, these are the sort of things that need to be pointed out in your full and frank disclosure, or you're going to come a cropper against that collateral use and against the suggestion that what you've done is absolutely not what you were entitled to do under the search order. And so it is really, and that's what happened in Owen Holland. So it's important to think about that when you're drafting your order, when you're managing clients' expectations, if you're acting for a claimant. That's something you need to be drawing to the attention of the court if you want to do it. So that's very quickly the modern approach to search orders. In relation to that, it does seem to me that the court will make those less intrusive orders. So I've mentioned that imaging can be less intrusive. It might lead to fewer premises, fewer locations for your search. I did one case, which isn't up there actually, but where we got an order where the defendant was ordered to deliver up computers on the doorstep for imaging. And if the supervising solicitor, and we did have a supervising solicitor, if the supervising solicitor wasn't satisfied with the delivery up, then they could commence a search. So it was a sort of contingent search order with, we won't come and search, it was in that case domestic premises 2 days before Christmas. We won't come and open all the Christmas presents to see if you've hidden the computers inside them. If you can satisfy us that you have cooperated and delivered them up on the doorstep. And that's the sort of innovative order that the court might consider.
And presumably you're going back at the return hearing to get the order to review the documents.
Yeah, if you can show that you need them. But actually, if it's only about preserving them, that might happen through the ordinary disclosure process. And of course, the disclosure regime now, which is so painful, but it does give quite a degree of clarity in fraud cases about how that disclosure is being carried out. And so you don't have the same thing where you actually don't know what they've done to identify what the relevant documents are, because you've agreed all your keywords, you've agreed your parameters and so on. So there is quite a lot more visibility over that. And so in that sense, I think where there are solicitors on the record, the courts are more willing to leave that to the disclosure process in the ordinary way, unless you can show some urgency for getting the information. I think where it becomes more of a problem is where you've got a litigant in person as a defendant, and then there isn't that trust about the way that's done. And the court then, I think, would be much more flexible about considering how to ensure that that's done properly. And I've had orders about that too, where litigants in person have been obliged to disclose who they're going to use as an electronic disclosure provider and what keywords they're going to use and so on beforehand, so that that can be, whether or not that is a robust system can be tested in front of the courts. I know that we're all gasping for a drink. So I just want to mention very quickly, we've done freezing orders, we've done asset disclosure orders, Norwich Pharmacal and Bankers Trust orders, notification orders, effectively like a freezing order, but it's not frozen, you just have to say before you dispose of an asset. It's basically freezing order light, but you have exactly the same obligations as a freezing order. So from a claimant's point of view, it doesn't necessarily look very attractive, but maybe if you've got a judge who isn't keen, that might be a possibility, if it looks less intrusive, to have a notification rather than the freezing order. Doorstep delivery up orders I have, that's the search order light version. And then just to say, these are all strongly supported by the court's powers to enforce its own orders. As I said, the court does not want to make orders that can't be enforced or aren't enforced. So cross-examination on assets, under CPR 71, under the inherent jurisdiction 37(1) of the Senior Courts Act again, an order that the defendant takes steps, including to write to banks, to to provide information like is Berlin and Turk, or to direct transfers that should be made. And where an order's breached, you might get a further order that someone else takes a step that the defendant should have taken. So the court sort of steps in and requires somebody else to write the letter that requires the bank to give information or something like that. The courts are willing to do that, citing section 39(1) of the Senior Courts Act, but that's only once an order has been breached. You can do that as an enforcement. Bespoke orders like the one in London Partners Capital and Utcan, not to go and access the storage facilities. Passport orders and committal for contempt. And the courts have been committing people for contempt. In the Lusitania case, the defendant has had 3 separate periods of imprisonment, 9 months, 21 months and 24 months for failing to comply with freezing orders. And those are consecutive periods of imprisonment, I think. So there is that final sort of very big stick to use of the contempt order. I think maybe I think other people have things to say about passport orders, so I'll.
Well, not really. One thing I want to say is I think notification orders are very useful. If you've got a case where you're not sure that your evidence is strong enough to justify a freezing order, that judges are often much more willing to make an order requiring the defendant to notify you 7 days before they dispose of a particular asset, that which then puts the onus on you then to apply for an order freezing the asset to restrain the disposal of the asset. Those are very useful, and in practical terms, often they're as effective as old-fashioned moreover injunctions. The other point I would make, Victoria's already made the point really well, the orders to requiring parties to take steps in relation to their own assets to procure transfers from bank account A to bank account B can be really useful. And as Victoria says, the court then has jurisdiction if the respondent doesn't comply with the order to appoint someone to take that step on their behalf. And it can be an incredibly useful way of cracking a case, actually, where you've got a recalcitrant defendant who isn't in the business of being cooperative, as is invariably the case. I've got a couple of questions just for Jessica at the end, really. I see that time is racing. It's to do with search orders. Why, Jessica, would you say it's useful to involve an investigator prior to and during a search order?
I think prior to search order it can be useful. There are some elementary steps that we can help with. I mean, the first are very obvious. You know, where does the subject or where is the entity based? If it's an individual, does he spend Monday to Thursday in one jurisdiction, in one house, and does he spend the weekend somewhere else? Again, how do you access the property? Is there high security? Does he have 3 Alsatians and a security guard? You know, who else might live there? Is there a vulnerable person? And again, the pattern of life. You know, does he leave the house every day at the same time? We want him to be at home. Or does he work all nights, you know, as a high-flying DJ and only get up at 11 a.m.? So these things, I think, are elementary, but also can help. I think the second way is we can help identify how many devices the subjects or the entity might have. To give you an example of this, in a previous matter we worked on, the defendant had failed to comply with the delivery up order of his electronic devices, claiming that he had mislaid them, which is incredible in this day and age, and he had a lot of them. Unfortunately for him, we actually identified an image of his study in a real estate brochure that had been published online after the order, which kindly showed several electronic devices, and this information was subsequently passed to the lawyers who applied and were granted a search order. And needless to say, the judge was fairly unimpressed at that point. So I think that's...
Well, very good. Well, thank you very much. You mentioned mysteriously losing phones. I am reminded of the article I think I read in the Times the other day. Is it called the Wagatha Christie case, where one key witness who is strangely not able to give evidence, I believe, dropped her phone in the North Sea, which I've just so pleased by that. I can't really understand why it tickles me. We've reached the end. It's now 6 o'clock, and I believe there are drinks and canapes and possibly even dance music available.
Unless there's any questions on.
But we do have a couple of, I've been reminded to say, we do have some time for questions. If anyone has a question, please ask it now. If you're not asking a question, I'll take that as evidence, not of exhaustion, but of just the sheer comprehensiveness of the talk that you've just been enjoying. I don't believe we have any online questions. Does anyone have any questions they'd like to ask? So basically we're all heading for the bar. Very good. Well, I'd like to thank everyone for taking part. I'd like to thank you particularly for sniggering at my jokes, and I look forward to meeting you in a few minutes' time. Thank you.
I will find the time, we will find the timing.